Mr. Carnes, thank you. And Mr. Burdette, I've been presented with the order on James Dennison, which is case number 252154 SM. I note the time period is not cited in the order. Is there any objection to me adding handwriting within 30 days?
Please do so, Your Honor.
So the order will now read further prosecution not in the interest of justice at this time. People will recharge if and only if the defendant fails to provide proof of attendance at anger management or alternatives to violence, class, or counseling within 30 days.
Yes, Your Honor. Thank you.
Mr. Burdette, are you all right with that?
Yes, Your Honor. Thank you.
All right, I have signed the order and you can get a copy of it at the front window.
All right, thank you.
All right, now we are back on People of the State of Michigan versus Jessica Lynn Conway, case number 252340 SM. Appearances, counsel.
Courtney Lawrence on behalf of the people.
Ava Jomera on behalf of Ms. Conway.
And we are here for a final pretrial conference. Is there any resolution?
There is, Your Honor. The defendant has agreed to plead no contest to count one, retail fraud third degree, and the people have agreed to a delay of sentence.
And the reason for the no contest plea?
Civil liability, Your Honor.
Is there any restitution requested? Looks like it's set at 0.
There is not, Your Honor.
So just out of curiosity, what is the potential civil liability?
Your Honor, the potential civil liability would be damage to a coloring book.
Damage to a coloring book?
Yeah.
But they're not requesting restitution.
No.
Has the item been returned?
Yes.
Ms. Lawrence, has there been any conversation regarding restitution with the store?
I'm not sure, Your Honor. I believe our victim's advocate reached out and there was no request for restitution.
It's a very weak stretch, but I will make the stretch for today. So, Ms. Ejomera, is that your understanding of the plea agreement?
Yes, sir.
Ms. Conway, have you heard what the attorneys have said the resolution in this case is?
Yes, sir.
And is that how you wish to resolve it?
Yeah.
Please raise your right hand. Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you put your hand down. It's my understanding that you will be pleading no contest due to civil liability to a charge of retail fraud third degree, which is a misdemeanor punishable by up to 93 days in jail and or a fine of $500 or 3 times the value of the property taken if the prosecution can meet certain requirements. As I said, the reason for the no contest plea is potential civil liability. So a no contest plea allows the court to review a document, presumably it'll be a police report, to determine whether or not there's a factual basis in which to find you guilty of the offense. The no contest says that you accept responsibility without saying that you're guilty. A guilty plea, if the store were to choose to go after you civilly, could be used against you in that civil case. No contest plea does not allow that to happen. The court could also use that same document then for sentencing purposes as well. Do you understand that? Now, along with this is you have a Killebrew agreement with the prosecutor. And what that Killebrew agreement is that the court would place you on a delay of sentence. Presumably, Ms. Lawrence, it would be a dismissal at the end of the delay.
Yes, Your Honor.
And if you are successful with the terms of that delay of sentence, the case would be dismissed and not show on your public record. Do you understand that?
Yes.
Now, that's an agreement you have with the prosecutor, and that's not an agreement you have with me. So if I decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that?
Yeah.
All right. Other than the plea agreement today, has anybody promised you anything in order to get you to plea? No? Has anybody threatened you in any way?
No.
And is it your own free choice to plea? Back on, are you able to hear her, Danny? Back on June 1st, were you on probation or parole? Were you on bond in any other matter? Do you remember reading and signing this advice of rights form, talk about your rights to a trial, your rights to an attorney? Did you understand those rights? Most importantly, do you understand that by entering a no contest plea today, you'll be giving up those rights and you won't have a trial of any kind? Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
Then, Ms. Conway, to the allegation that on or about June 1st, 2025 in the city of Cadillac or Wexford County, how do you plead to the offense in count 1 of retail fraud 3rd degree? No contest? Ms. Lawrence, do you have an exhibit for the court?
Yes, Your Honor.
All right, I've been provided what's marked as People's Exhibit number 1, which is a City of Cadillac Police Department report number 25-001461. Ms. Lawrence, are you moving for its admission?
Yes, Your Honor.
Ms. Ejimera?
No objection.
People's 1 is admitted. Give me just a moment to review that. All right, I've reviewed that. Do counsel believe that Exhibit number 1 provides a factual basis in which to accept the no contest plea and for a finding of guilt?
Yes, Your Honor.
Yes, Your Honor.
Do counsel believe the court rule has been complied with?
Yes, Your Honor.
Yes, Your Honor.
One question I have, Ms. Lawrence, is the complaint says it was Twisted Bones open to the public. And the report says that they responded to another vape shop. That's the name of it, another vape shop. But it also lists the victim as Twisted Bones. Having never been there, I believe they're one and the same. Am I correct on that?
I believe they are as well, Your Honor.
All right,
I have been there in the same store.
they are the same store. Do you take any issue with the variances in the report?
No, Your Honor.
All right. All right, the court finds that the People's Exhibit number 1 makes out a factual basis in which to accept a no contest plea to count 1 retail fraud 3rd degree. I also find the interests of justice are served allowing the defendant to enter a no contest plea to avoid potential civil liability. In particular, People's Exhibit number 1 indicates that on or about June 1st, 2025, law enforcement were called to the venue that we discussed, which is located here in the city of Cadillac. Surveillance video showed Ms. Conway picking up a coloring book and placing it in her purse without paying for it. She then turns the coloring book over to law enforcement and finds herself here today. So I find that she is guilty of retail fraud 3rd degree. Are we able to sentence today?
Yes, Your Honor.
Is there any victim impact, Ms. Lawrence?
There is not.
Allocution, Ms. Edmund?
Your Honor, obviously, this case is sort of not very serious. Not so much that, you know, the allegations of stealing are not serious, just that it's a coloring book, and it was returned. Obviously, I don't want to jeopardize the plea that we took today, but I do think that had we taken it to trial, there may have been problems with things. That being said, I don't think Ms. Conway intended to take, or intends to continue making decisions like this or mistakes like this, whatever you want to call it. And I believe the delay of sentence is appropriate with a retail fraud prevention class. Thank you.
Thank you. Ms. Lawrence?
Your Honor, people do understand this is a fairly minor retail fraud case and the property that was taken was returned. I do think a short delay of sentencing would be appropriate. I do understand, at least to my knowledge, that Ms. Conway does not have any criminal history. So I think a short delay would be appropriate with the retail fraud class. Thank you.
Thank you. Ms. Conway, you had the right to address the court prior to sentencing. Is there anything you'd like me to know? No?
Just the fact that I think it was a mistake and I did not read it.
All right, I'm not going to ask you any questions because it was a no contest plea, but I will say, at least the way the report reads, you opened up your purse and stuck a coloring book in it. It's lost on the court how you did not intend to do that. And I hear, I hear this a lot, that these are just retail frauds. And I always get baffled when I hear that because yes, it's a retail fraud, but it is a victim crime. And this is a local owner who, I'll be honest, I have no connection with this owner at all, other than I know who they are, but that's only because I know him from being a victim when I was the prosecutor. But I do know enough about the local businesses to know that you taking a coloring book, even though it's a coloring book, it's valued at $11 and some odd cents. That's $11 and some odd cents that you physically stole from somebody's pocket because it's a small business. So to sit here and tell the court that these aren't major offenses, I just don't buy it. Every time somebody steals something, it has an impact on everybody, whether it's a small business or it's Walmart. Expenses go up, law enforcement has to get involved. So that just gets lost on the court. I will never understand that argument. With that said, I do realize that this is your first offense. You have no prior history at all. So I believe that a delay of sentence is appropriate in this case, and hopefully you have learned your lesson. And I won't see you back at that table. And the audience is one thing, but at that table, I hope I don't see you back. So I will follow the recommendation, or I'm sorry, the Killebrew agreement. I am going to put you on a period of probation for 12 months. Now, because this is a delay of sentence, this is not eligible for early release. So you are going to have to, you're not eligible for early release. So you have to serve that full 12-month delay of sentence. That's the maximum I have available to me under the Delay of Sentence Act. During that time, you are not to violate any law. Report is ordered, not leave the state of Michigan without the consent of the probation officer. Keep your contact and employment information current. As I said, you are not eligible for early release. During the period of time that you are on probation, I'm going to order that you attend any retail fraud classes, theft or larceny classes that your probation officer feel is appropriate. In any additional counseling, Ms. Lawrence, what about a no contact order during this time period?
I'm fine with a no contact order during probation.
All right, then no contact order will continue, which means for the next year, you are not allowed in that store. There is a $75 crime victims' rights fee, $50 state minimum fee. $150 fine. You stated that you're a caregiver for your brother. How much do you make doing that? $100 a week. I will waive the court costs and I'll waive attorney fees. Probation is $360. There is no restitution requested, so I'll mark that as none. There's no jail on this, right? 0 days jail with 0 days credit. Ms. Conway, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. That's by operation of state law. I'll need you to go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to, and then go downstairs and sign up for probation at the district court probation office. All right? All right. Good luck to you.
Your Honor, I didn't mean to insinuate that I didn't take the charge seriously, if that's.
No, and I didn't take it that way, but that's something I hear quite a bit. And to say that they're minor offenses, yes, it's a misdemeanor. I get that.
I just wanted to apologize.
No, I understand. Thank you.
Your Honor,
Yes, you may retrieve the exhibit. Court next calls the people of the state of Michigan versus Rachel Marie Shook. This is case number 252407 SM, appearance as counsel.
Isaac Thomas on behalf of the defendant, who sat to my right, Your Honor.
Joanna Carey, on behalf of the people.
All right, and we are here for a final pretrial. Is there any resolution in this case?
Yes. It looks like the defendant is going to plead guilty to count 1, and the people will dismiss count 2.
So has that been amended then since the sheet that was presented to the court?
Well, I think the sheet is wrong.
The sheet's wrong? Okay,
It doesn't make sense. The way it is.
I see that now. All right. So plea to count 1, dismiss count 2.
Correct.
Mr. Thomas?
Yes, that's my understanding, Your Honor.
Ms. Shook, have you heard what the attorney has said the resolution in this case is?
Yes, Your
And
Honor.
is that how you wish to resolve it?
Yes, Your
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? You may put your hand down. Ma'am, it's my understanding that you'll be pleading guilty to retail fraud second degree, which is a misdemeanor punishable by up to 1 year and or a fine of $2,000 or 3 times the value of the property taken if the prosecution can meet certain requirements. In exchange for that, the people will dismiss count number 2, which is another retail fraud second degree. Is that your full understanding of the plea agreement? Back on April 24th of this year, were you on probation or parole? Were you on bond at the time? You were on bond for retail fraud, if I remember correctly. Is that true? Yes. Do you remember reading and signing this advice of rights form? Talked about your rights to an attorney and your rights to a trial. Did you understand those rights? Most importantly, do you understand that by entering a guilty plea today, you'll be giving up the right to have a trial and you won't have a trial of any kind? Other than the plea agreement, has anybody promised you anything?
No,
Has anybody threatened you in any way?
no.
And is it your own free choice to plea today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements made not made part of the record?
None, Your Honor.
Then Ms. Shook, to the allegation that on or about April 24th, 2025, in the city of Cadillac in Wexford County, you committed the offense of retail fraud second degree while at Maxie. How do you plead?
Guilty, Your Honor.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on April 24th of this year, were you in the city of Cadillac?
Yes, Your Honor.
And were you at that store?
I was.
And did you attempt to, or were you successful in taking some merchandise that was offered for sale? And did you actually get out of the store with it? And what is it that you took?
A dress.
And what was the value of that dress?
$28, I believe.
And is it also true, and you did not pay for that dress?
I didn't.
Is it also true that back on March 21st of 2004, you were convicted of retail fraud second degree here in the 84th District Court?
Yes, Your Honor.
I apologize, Your Honor. So the record, 2024, not 2004. I'm sorry.
No, thank you for that. It's clear as day, 2024. Why I said 2004, I have no idea.
Thank you.
So let me rephrase that. Is that also true that you were convicted of retail fraud second degree in this court back on March 21st, 2024? All right. Do counsel believe the defendants provided the factual basis to accept the plea and the court rules have been complied with?
I do, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Shook, I find you guilty of retail fraud second degree and count 1 pursuant to the plea agreement. Retail fraud second degree and count 2 will be dismissed. Are we able to sentence today?
We are.
Any allocution, Mr. Thomas? Well, I should say I have received a letter from Leslie Burns dated August 27th.
Thank you, Your Honor. And that was a letter that I was going to refer in at the opening. I believe this letter, without reading into the record, says a lot of what I'm going to say about Rachel today. This court did see Rachel a few months ago for retail fraud, and this did arise out of the bond violation. I don't bring that up to say anything other than Rachel was in a very bad place back then and is in a much better place now. She is engaging in counseling. She's employed. She has a place to live. She has no intention of doing anything like this ever again. And if I may add on to the theme that's been in this court on the record today, I don't believe this court will see Ms. Shook in this courtroom in the future. For those reasons, I ask that this court sentence Ms. Shook to fines and costs, allowing her to continue making these good choices and moving on with her life. Thank you, Your Honor.
Thank you, Ms. Carey.
Well, I appreciate the letter from the Lakes, and I understand the issues that it discusses in there. I unfortunately don't share Mr. Thomas's optimism that we won't see her again, because we've seen her so many times. And she continues to make these decisions. On this incident, she was in 2 different stores stealing. And I know I dismissed 1 and she only pled to 1, but the fact remains, it's not her first time. She's got other ones. Makes me wonder how many times she hasn't got caught, because she keeps doing it and she knows better. And whether the mental, I understand the mental health issues, but I'm also certain that she knows right from wrong, and I'm certain that she knows stealing is wrong. So frankly, and you want to talk about small businesses trying to improve our downtown, it's these businesses that she was stealing from. So I'm frustrated. I'm frustrated by it, and I am not all that. I don't know what to do, because I'd like to frankly have a jail sentence, but I think at least that probation is necessary. Thank you, given her record.
Ms. Carey, was there any restitution requested?
I believe they got the items back, even though she was wearing them, some of them.
Okay. Ms. Shook, you have the right to address the court. Is there anything you'd like me to know before sentencing?
Your Honor, I am really sorry. I really do get messed up in my head with the mental illness that I got going on. And I don't think about the consequences, and I can't hold a job because of my schizophrenia, because I talk out loud. And I didn't have any clothes, so I didn't go to the downtown shops. And the more you guys talk about this in court, that I'm affecting a downtown business. I'm mom and dad own small businesses. I don't know what I'm doing, but I'm really able. I have gotten a job and kept it. That I'm able to work right now is an outside seasonal job. I'm waiting on Social Security. I do have an apartment. I see my kids as much as possible. And I'm asking you to take that into consideration.
So, that was on the previous.
Yeah.
Looks like on your previous cases, I had released you to treatment. Did you, I'm assuming you successfully completed that, because I haven't
Yeah.
got any violations on that. When were you done with that?
I was done with treatment in November of 2024.
So I didn't release you to treatment, the prior judge released you to treatment.
Yes.
Your Honor, if you're referring to the case from a few months ago, it was the fines and costs that she was
And
sentenced.
if I recall correctly, that was because that case was so old, if I remember.
I believe that was the court's reasoning, but yes.
Ms.
Your Honor.
Carey's shaking her head, yes. Are you currently on probation?
I am not, Your Honor.
Okay. And so you've been attending counseling, it looks like, since May, off and on.
No, this has been for 3 years. that
This has
I've with
been
the ACT,
steady?
But I just recently got put on the shots because I wasn't taking my medications.
Okay, okay.
So they just put me on injectables instead of having to take them weekly. So I make sure I get my medicine.
How are you finding that?
I'm finding it really effective. I need to hang in there.
And how long have you had housing?
Since we had court.
If I recall correctly, and please correct me if I'm wrong, but at the bond violation hearing in the other case, you had indicated that you had taken these clothes, so you had clothes for a new job. Is that accurate?
Yes,
And then that business never opened up.
and that business didn't open up.
Well, Ms. Shook, Ms. Carey's right for all intent and purposes. I mean, going through your history, you've had some drug issues. But in 24, you had a retail fraud third. May of 25, you had the retail fraud second. Then you pick these up. You know, for all intent and purposes, you deserve a jail sentence. You know, one of the things that the court does before it puts a person on probation is it has to be convinced pursuant to statute that there's a likelihood of reoffending. And your history certainly doesn't bear that out. However, I'll also say another goal of probation is rehabilitation. And the last thing I want to do is take away the services that you have already gained. You know, I realize that you've been working with the ACT team since '01, but that didn't stop a couple retail frauds. I'm sorry, I said it again, since 21. I'm stuck in my youth, I guess, today. I don't know what's going on.
It was the beer, Your Honor.
So, you know, that hasn't helped you all the way through with these retail frauds because you picked up retail frauds while still working with the ACT team. But I think some things have changed that you didn't have before. You mentioned the medications, you've mentioned that you're now holding a job and that you've got housing. So I'm willing to take that all into account and not put you in jail, but by all intent and purposes, you should be in jail. Just so we're all clear on that. I am going to put you on a period of probation. I've got 2 years at my disposal, and I think 2 years is appropriate in this case. I think you can give me 2 years of probation in exchange for not going to jail. I don't think that's too much to ask. And I think the probation hopefully will keep you engaged and hopefully stop the behavior and the spiral that you're going down. So I'm going to place you on probation for 24 months. During that time, you are not to violate any law, report as ordered, not leave the state of Michigan without the consent of your probation officer. Keep your contact and employment information current. Now, this charge does allow you to be released early from probation. So if you've done everything that we need you to do at the halfway mark, you could be released. If something happens that your probation officer doesn't think that you should be released, but you think you should, you can petition the court on your own and we'll have a hearing and I'll make that decision. During that period of time, I am going to order that you attend any counseling that your probation officer feels is appropriate, comply with any CMH treatment that's necessary. I'm going to order a retail fraud or theft and larceny class. I'm going to order that you be employed during probation because I think that's going to help quite a bit. Do you have your diploma?
Yes.
All right. I'm sorry, did you say you're working on disability, trying to get disability? All right. During this time period, I am going to continue the no contact order with the store. So you're not allowed in that store at all. And any additional programming that your probation officer feels is appropriate. Is there any jail credit on this? All right. 0 days jail with 0 days credit. There is a $75 crime victims' rights fund fee, $50 state minimum fee. Because this is not your first go around and you've pled to a retail fraud second degree, I'm going to impose a $500 fine, $150 court costs, and $150 attorney fee.
I may waive that, Your Honor. I apologize.
We can waive that. Probation, I'm only going to charge you half of the probation fee. So I'm only going to charge you for the first year, which is $360. If something happens that you stay beyond that 12-month mark, you're going to be required to pay that monthly probation fee. Any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that by operation of state law. Do you have any questions for me about your sentence?
No, Your Honor.
Ms. Carey, anything I've missed in a judgment of sentence?
No, thank you.
Mr. Thomas?
Nothing, Your Honor.
All right. Ms. Shook, you can go out to the front window where you checked in, get a copy of your judgment, make payment if you're able to. If not, get set up on a payment arrangement. I'm not sure, do we have a payment plan for you going now?
Yes.
All right, so we'll add this to that payment plan. But that does not stop the 20% from being added.
All
so
right,
you're
let's
aware.
talk about that. This Wexford County docket gave us two very different shoplifting cases, one a one-time mistake, the other a repeat problem. And the judge's responses reflected that difference. Was Jessica Lynn Conway, charged with retail fraud in the 3rd degree for slipping a coloring book into her purse at a local store. She pled no contest because of potential civil liability, even though restitution wasn't being sought and the book had been returned. The judge explained that a no contest plea avoids being used against her in a civil lawsuit and then accepted it. Because Conway had no prior record, the prosecutor and defense agreed on a delay of sentence, meaning probation first, with dismissal possible if she complies. Still, the judge took time to push back on the idea that shoplifting is minor. He reminded everyone that even an $11 coloring book hit small business owners directly. The result, 12 months of probation, a theft prevention class, counseling as needed, a no-contact order with the store, $75 in crime victim fees, and $150 in fines, but no jail. Then came Rachel Marie Shook, also in on retail fraud, but this was her 3rd time since 2024. She pled guilty to 1 second-degree charge, with another count dismissed. Her defense leaned on mental health struggles and a support letter from a treatment team, asking for fines and costs instead of jail. The prosecutor was frustrated, pointing out her repeat behavior and questioning how many times she might have stolen without getting caught. Shook herself admitted she struggles with schizophrenia, had been off medication before, and was now stabilized with injectables. The judge was candid. By all intents and purposes, you deserve a jail sentence. But he weighed the new stability, steady counseling, and employment against that history. Instead of jail, she got 2 years probation, counseling, employment requirements, a theft prevention class, no contact with the store, and $500 in fines. The judge warned she might be released early after a year if she stays compliant, but made it clear the court was running out of patience. The overall atmosphere mixed patience with exasperation. Conway got the benefit of being a first offender, while Shook walked out with probation instead of jail, only because of recent progress in treatment. Both cases underscored the judge's theme. Even small thefts aren't victimless, and probation is a privilege meant to stop the spiral before it ends in jail. Time to break this one down. Conway walked away with probation and the chance for a clean record, while Shook avoided jail but left with strict probation and the judge's warning that this really is her last chance. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.